Dear students, I welcome you to yet another lecture on corporate law. The theme of today's lecture is prospectus. The issue of prospectus is essential when the company wishes the public to purchase its shares or debentures. Section 2, Clause 70 of the Companies Act 2013 defines prospectus as any document described or issued as a prospectus and includes a red herring prospectus referred to in section 32 or shelf prospectus referred to in section 31 or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. On the basis of the definition we just discussed, a document should have certain ingredients. These are: there must be an invitation to the public. Number 2, the invitation must be made by or on behalf of the company or in relation to an intended company. Number 3, the invitation must be to subscribe or purchase. And lastly, the invitation must relate to any securities of the company. Thus, it is clear that a prospectus is a document that invites the public to subscribe to the share capital or debentures of a company. If it does not do that, it cannot be called a prospectus. Dear students, we shall now discuss public offer and private placement as provided in Section 23 of the Companies Act 2013. A public company may issue securities to the public through prospectus or through private placement, or through a rights issue or a bonus issue as per the provisions of the Companies Act 2013. And in case of a listed company or a company which proposes for public issue, it must also comply with the provisions of the Securities and Exchange Board of India Act 1992 and the rules and regulations provided under it. A private company may issue securities, number 1, by way of rights issue or a bonus issue in accordance with the provisions of the Companies Act, or through private placement by complying with the provisions of Part 2 of Chapter 3. Dear students, we shall now discuss the legal requirements regarding issue of prospectus. The Companies Act has mandated certain legal requirements about the issue and registration of a prospectus. The issue of the prospectus would be deemed to be legal only if the requirements are met. The first requirement is that issue must be after incorporation. As a rule, the prospectus of a company can only be issued after its incorporation. A prospectus issued by or on behalf of a company or in relation to an intended company shall be dated, and that date shall be taken as the date of publication of the prospectus. Number 2, registration of the prospectus. It is mandatory to get the prospectus registered with the Registrar of Companies before it is issued to the public. The procedure of getting the prospectus registered is: number 1, a copy of the prospectus duly signed by every person who is named therein as a director or a proposed director of the company must be filed with the Registrar of Companies before the prospectus is issued to the public. Number 2, a prospectus issued under Section 26 shall not include a statement purporting to be made by an expert unless the expert is not engaged or interested in the formation or promotion or management of the company, and the expert has given written consent to the issue of the prospectus and has not withdrawn such consent before the delivery of the copy of the prospectus to the registrar for filing, and a statement to that effect shall be included in the prospectus. There are certain documents that must be attached with the prospectus. These are copies of all contracts entered into with respect to the appointment of the managing director, directors and other officers of the company. These must also be filed with the registrar. If the auditor or accountant of the company has made any adjustment in the company's accounts, the said adjustments and the reasons thereof must be filed with the documents. A copy of the application which is to be filled for the issue of the company's shares and debentures must be attached with the prospectus. The prospectus must have the written consent of all the persons who have been named as auditors, solicitors, bankers, brokers, etc. Every prospectus must have on the face of it a statement that number 1, a copy of the prospectus has been delivered to the registrar for registration. Number 2, specifies that any documents required to be endorsed by the section have been delivered to the registrar. We must also remember that a copy of the prospectus must be filed with the registrar of companies. The registrar should register the prospectus only when number 1, the prospectus is dated. The date shall, unless the contrary is proved, taken to be as the date of publication of the prospectus. Number 2, the contents of the prospectus conform to Section 26 of the Companies Act. Number 3, the consent of the expert, if it is necessary, has been obtained, but such expert should not be engaged or interested in the formation or promotion of the company. Number 4, the written consent of the expert with respect to the issue of his statement included in the prospectus has been obtained. If these provisions of law have not been fulfilled or the necessary documents have not been attached, the registrar can refuse to register the company's prospectus. According to Section 26, no prospectus shall be issued more than 90 days after the date on which a copy thereof is delivered for registration. If the prospectus is so issued, it shall be deemed to be a prospectus, a copy of which has not been delivered to the registrar. If a prospectus is issued in contravention of the principles we just discussed, then the company and every person who is knowingly a party to the issue of such prospectus shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, or with both. Dear students, we shall now discuss the contents of the prospectus. The contents of the prospectus are provided under Section 26. Every prospectus issued by or on behalf of the public company, either with reference to its formation or subsequently, or by or on behalf of any person who is or has been engaged or interested in the formation of a public company, shall be dated and signed. The prospectus should furnish certain important information. This includes the names and addresses of the registered office of the company secretary, chief financial officer, auditors, legal advisors, bankers, trustees if any, underwriters and such other persons as may be prescribed. Dates of the opening and closing of the issue and declaration about the issue of allotment letters and refunds within the prescribed time. A statement by the Board of Directors about the separate bank account where all the monies received out of the issue are to be transferred, and disclosure of details of all monies, including utilized and unutilized monies out of the previous issue in the prescribed manner. Details about underwriting of the issue. Consent of the directors, auditors, bankers to the issue, expert opinions if any, and of such other persons as may be prescribed. The authority for the issue and the details of the resolution passed thereof. Procedure and time schedule for allotment and issue of securities. The capital structure of the company in the prescribed manner. Main objects of the public offer, terms of the present issue, and such other particulars as may be prescribed. Main objects and present business of the company and its location, schedule of implementation of the project. Particulars relating to number 1, management perception of risk factors specific to the project. Gestation period of the project. Number 3, extent of progress made in the project. Number 4, deadlines for the completion of the project. Number 5, any litigation or legal action pending or taken by a government department or a statutory body during the last 5 years immediately preceding the year of the issue of the prospectus against the promoter of the company. Minimum subscription amount payable by way of premium, issue of shares otherwise than in cash, details of directors including their appointments and remuneration, and such particulars of the nature and extent of their interest in the company as may be prescribed, disclosures in such manner as may be prescribed about sources of the promoter's contribution. Dear students, we now discuss about the reports that are to be set out in the prospectus. The prospectus needs to set out certain reports for the purposes of financial information, namely reports by the auditors of the company with respect to its profits and losses and assets and liabilities and such other matters as may be prescribed. Reports relating to the profits and losses for each of the 5 financial years or lesser period if applicable immediately preceding the financial year of the issue of prospectus, including such reports of its subsidiaries and in such manner as may be prescribed. Reports made in the prescribed manner by the auditors upon the profits and losses of the business of the company for each of the 5 financial years or lesser period if applicable, immediately preceding the issue and assets and liabilities of its business on the last date of the accounts of the business not exceeding 180 days before the issue of the prospectus. Reports about the business or transaction to which the proceeds of the security are to be applied directly or indirectly. A declaration about the compliance of the provisions of the Companies Act and a statement to the effect that nothing in the prospectus is contrary to the provision of the Companies Act, the Securities Contracts Regulation Act 1956, and the Securities and Exchange Board of India Act 1992, and the rules and regulations made thereunder. Such other matters and such other reports as may be prescribed. Subsection 2 provides that nothing in subsection 1 shall apply to the issue of existing members or debenture holders of a company of a prospectus or form of application relating to shares in or in debentures of the company, whether an applicant has the right to renounce the shares or not under section 62 in favor of any other person. 2. The issue of a prospectus or form of application relating to shares or debentures which are or are to be in all respects uniform with shares or debentures previously issued and for the time being dealt in or quoted on a recognized stock exchange. Dear students, we shall now discuss the public offer securities only to be in the dematerialized form as per section 29. Every company making public offer and such other class of companies as may be prescribed have to issue their securities only in the dematerialized form. Such securities must comply with the provisions of the Depositories Act 1996 and the regulations made thereunder. Dear students, we shall now discuss the shelf prospectus. The shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of a further prospectus. In other words, shelf prospectus means a prospectus issued by any financial institution or bank for one or more issues of securities specified in the prospectus. The concept of shelf prospectus has been introduced to save cost and time of the companies in issuing a new prospectus every time. Dear students, we shall now examine the conditions for the issue of shelf prospectus. Any class of companies, that is any public financial institution, public sector bank or scheduled bank whose main object is financing as prescribed by the Securities and Exchange Board, may file a shelf prospectus with the Registrar of Companies at the stage of first offer of securities. The validity period. The validity of the shelf prospectus shall not be more than 1 year from the date of opening of the first offer of securities under the shelf prospectus. No further prospectus is required in respect of a second or subsequent offer issued during the period of validity of the shelf prospectus. No requirement of filing fresh prospectus within 1 year. A company filing a shelf prospectus with the registrar shall not be required to file a fresh prospectus at every stage of offer of securities by it within the validity period of 1 year from the date of opening of the first issue of securities. Dear students, we now discuss the information memorandum. A company filing a shelf prospectus shall be required to file with the Registrar of Companies an information memorandum in respect of any changes in material facts, that is, in creation of new charges, changes in the financial position occurring since the first offer of securities or between the previous offer of securities and the succeeding offer. Refund of money without filing information memorandum. If a company has received application for the allotment of securities along with advance payments before filing the required changes with the Registrar of Companies, and if the applicants express a desire to withdraw their application, the company shall refund the subscription within 15 days from the date of withdrawal application. Filing with the Registrar of Companies. Any class or classes of companies as may be prescribed by the Securities and Exchange Board of India shall file a shelf prospectus with the Registrar of Companies. After filing the information memorandum, if any, securities are offered, the information memorandum along with the shelf prospectus shall be deemed to be a prospectus. Dear students, we now discuss the red herring prospectus. The explanation to section 32 defines the expression red herring prospectus as a prospectus which does not include complete particulars of the quantum or price of the securities. A company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of the prospectus. A company proposing to issue a red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and the offer. A red herring prospectus carries the same obligations as are applicable to a prospectus, and any variation between the red herring prospectus and a prospectus have to be highlighted as variations in the prospectus. Upon the closing of the offer of securities, the prospectus stating the total capital raised, whether by way of debt or share capital, and the closing price of the securities and any other details as are not included in the red herring prospectus shall be filed with the registrar and the Securities and Exchange Board. Upon the closing of the offer of securities, the prospectus stating the total capital raised, whether by way of debt or share capital, and the closing price of the securities and any other details as are not included in the red herring prospectus shall be filed with the registrar and the Securities and Exchange Board of India. Dear students, this was all with regard to today's lecture on prospectus. In today's lecture, we tried to understand the meaning of the term prospectus. We also tried to understand the contents of the prospectus. We also tried to understand what is meant by a shelf prospectus and a red herring prospectus. I hope you have been able to understand and enjoy the lecture. Thank you and stay blessed.